Is there a problem? I'm getting a feedback. No? Okay, let's go again. Je déclare.
I call this meeting to order. Welcome to meeting number 50 of the House of Commons Standing Committee on Canadian Heritage. I would like to acknowledge that this meeting is taking place on the unceded traditional territory of the Algonquin Anishinaabe people.
Now, in keeping with the order of reference adopted by the House on Tuesday, May the 31st, 2022, the committee's meeting on the study of Bill C-18, an act respecting online communications platforms that make news contents available to persons in Canada. Today's meeting, of course, is taking place in a hybrid format, again pursuant to the order of Thursday, June the 22nd, 2022. Members are in person in the room, and they all know how to access their interpretation, and they all know what to do. But for those who are attending virtually, I'd like to make a few comments for the benefits of the witnesses that are attending. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon at the very bottom of your screen to activate your mic and mute when you are not speaking. Interpretation for those on Zoom, of course, you have the choice at the bottom of your screen, which is a little globe, and then you can actually press that and get your interpretation in English or French. A reminder that all comments should be addressed through the chair. Okay, that's enough for housekeeping. In accordance with your routine motion, I'm informing the committee that all witnesses have completed the required connection test in advance of the meeting and are using the House of Commons approved equipment. So thank you very much. Now, just to quickly let you know, we have a list of witnesses, and I will leave Ms. Charette for the last because she's not here yet. But what I will say to witnesses is you each have 5 minutes. And even if you come as an organization, you still only have 5 minutes. So you can pick who you want to speak on your behalf. I will give you a 31-second shout out, and that literally is a shout. I will shout out to you that you have 31 seconds left. We need to really stick to times here because, of course, we will not be able to get the number of questions and answers and getting everybody to be able to do what they can do. So here we go. I'm going to begin we have as our panel, as witnesses, Conrad von Finkelstein, former chair of the CRTC, the Canadian Radio, Television, Telecommunications Commission. We have Ms. Annick Charette, who is president of the Fédération Nationale des Communications et de la Culture. We have Meta Platforms with Kevin Chan and Mark Dinsdale, who are representing them. Kevin Chan is the Global Policy Director, and Mark Dinsdale is the head of Meta Partnerships in Canada. And then we have Open Media, represented by Matthew Hatfield, Campaigns Director by video conference. So I will start with Mr. von Finkelstein. Mr. von Finkelstein, could you please begin?
Yes.
You have 5 minutes. Thank you.
Thank you, Madam Chair, for inviting me to comment on Bill C-18. As you know, the stated purpose of the bill is to regulate digital news intermediaries with a view to enhancing fairness in the Canadian digital news marketplace and contributing to its sustainability. The underlying rationale of this bill can be summed up very simple. Local news publishers do not get an appropriate recompense for the news that they produce, but that reaches the public via digital platforms. To rectify the situation, the Act contemplates a mandatory bargaining process between the platforms called Digital News Intermediaries, or DNI, and publishers called ENB. The process is very simple. DNIs have to identify themselves. EMBs are qualified by the CRTC. Then they have to bargain. The bargain is mandatory. It has to be done in good faith. If the bargaining fails, there's mediation. And finally, if mediation fails, there's a final offer of arbitration. All of this is done under the auspices of the CRTC, who designates the parties, manages the process, furnishes the panel of arbitrators, and is advised throughout. I'm not here to question the rationales of the legislation nor the method adopted. Rather, I like to share with you some problems that I see in implementing this legislation. This should not be taken that I support this legislation, however. It goes without saying that implementing this bill will present the CRTC with a huge new challenge. I look at these issues from the perspective of former chairman of the CRTC. When you implement a bill, the legislation should be specific, objective, and this is very helpful to the administrator, while vagueness and overly broad discretion means numerous demands, contestations, and delays. There are 5 points that I would like to bring to your attention. Who does this act apply to, or how do you identify the DNIs? I am sorry if there's a spelling mistake and it's ENI in your papers. The bill requires the DNIs to self-identify and notify the CRTC. The criteria is based on whether there is significant bargaining power imbalance between the operator and the news business, and if it's based on such criteria as the size of the intermediary, the market of whether the market gives the intermediary strategic advantage, and whether the intermediary occupies a prominent market position. These concepts, size, market, strategic advantage, prominent position, are all borrowed from competition law and very much depend on the context. They do not have an objective meaning. Rather, it seems to me this is going to be a dog's breakfast trying to identify DNIs. Rather than asking companies to self-identify and giving the CRTC powers to compel information to decide if the respondent is in DNI, the bill should be amended and provide that the minister, by regulation, after consultation with the Commissioner of Competition, designates the DNIs. Secondly, who benefits? On request of the CRTC, the CRTC must designate a business as ENB if it is a qualified Canadian journalism organization, as under the Income Act. Fine. Or produces news content that is primarily focused on matters of general interest and reports current events, regularly employs 2 more journalists, operates in Canada, produces news content that is primarily focused on a particular topic, not primarily focused on a particular topic. This is a very wide definition. It does not include government or overt political actors. It does not exclude foreign actors. It has no reference to journalistic standards, and it would seem to include even broadcasters who are obviously registered, regulated by another statute. In my view, this section should be amended to provide that ENBs have to be Canadian-owned and controlled, adhere to journalistic standards as set out in the Code of Ethics of the Society of Professional Journalists, and should not include licensed broadcasters and their affiliates or government actors. Third, the bill allows the criteria to exempt in DNI if it has an agreement with an EMB. That agreement must provide fair compensation for the news business, to the news business for the news content. That's fair ball. That's what it's all about. But then it goes on and says, ensure that an appropriate portion of the compensation will be used by the news business to support the production of local, regional, and national news content.
30 seconds.
Does not allow for corporate influence, etc. There's all these points. If you look at them together, they are really purposes. They should not be here, but they should be in the purpose section. Lastly, there's an undue preference and reverse onus provision. Basically, any ENB that feels it is discriminated by DNI can complain to the CRTC. They will investigate, and they can then give penalties for a violation. This is a complete misunderstanding of what a DNI does. It does millions of decisions each day.
Thank you,
it makes
Mr.
this
decision. I would hope that you would wrap up because you are going a little over your time. Thank you.
Thank you very much. This is a misunderstanding of the DNI, and the very simple thing this done is a computer decision. There are millions of them now. What should be done is that the DNI should explain, if there's a complaint, explain how its algorithm works, that it's fair, it's not unjust, it's not undue, etc. And in that case, the reverse onus, which is in the legislation, which means the allegation is true unless rebutted, makes sense because it's the algorithm of the DNI that we're talking about. They create it, they set it up, they should be able to show that it doesn't discriminate or disadvantage anybody. Thank you, Madam Chair.
Thank you very much, Mr. Von Fick. Thank you. And I would like to ask if, I think somebody's got their mic open on the floor, so I can hear my echo. I know I love to hear the sound of my voice, but not that much. The clerk, I wonder if you could let me know when Ms. Charette comes on. I don't see her on yet, but if you can just give me a heads up. So I would now like to move to Meta Platforms, Mr. Chan and Mr. Dinsdale, and I don't know which one of you would be doing the speaking.
It's going to be me, Madam Chair.
All right, for 5 minutes, Mr. Chan.
Madame la Présidente.
Madam Chair, committee members, thank you for inviting me to speak today on Bill C-18, the Online News Act.
Today, we want to share directly with the committee our concerns about this draft legislation and the unintended consequences we worry may flow from it in the fullness of time. We have three main concerns. They are: one, the true division of value between platforms and publishers; two, the unintended consequences of payment for free marketing; and three, the stifling of innovation. First, the framework of the current legislation presumes that Meta unfairly benefits from its relationship with publishers, when in fact, the reverse is true. The Facebook platform helps publishers. Meta does not scrape or index news content or links. Like any business, nonprofit, or public or political organization, Canadian news publishers choose to share links from their websites on Facebook to reach a wider audience that leads to increased readership of their stories. This in turn allows them to sell more subscriptions and advertising. In Canada, we estimate that Facebook feeds sent registered publishers more than 1.9 billion clicks in a single year. Free marketing for their content in the form of link posts that has an estimated value of more than 230 million Canadian dollars. Simply put, this is what it would have cost news publishers to achieve the same outcome on Facebook if that space wasn't provided to them for free. So you see, Facebook already helps Canadian publishers to the tune of hundreds of millions of dollars a year. Vous voyons donc.
So you see, Facebook already helps Canadian publishers to the tune of hundreds of millions of dollars a year.
Second, the Online News Act would force Meta to pay news organizations for content that publishers voluntarily place on Facebook. In blunt terms, we would be forced to pay publishers for giving them free marketing on Facebook, which I just noted was valued at $230 million last year. This would be a most peculiar and unorthodox arrangement. In the current economic climate, and as we prioritize long-term investments in the metaverse and in the growth of short-form video in response to competition and user preferences, we are being asked to acquiesce to a system that lets publishers charge us for as much content as they want to supply at a price with no clear limits. I hope you will agree with me that no business can operate this way. Third, successful regulation must be grounded in fact. We have long supported regulation that sets clear and fair rules for everyone and an open internet where creativity and competition can thrive. But as independent experts have warned, a policy that unfairly subsidizes legacy media companies that have struggled to adapt to the online environment is an approach that will harm competition, reduce trust in media, and make the transition to digital models even more difficult. A recent report by the Parliamentary Budget Officer only underscores these real concerns. According to the PBO's analysis, it is broadcasters, including the public broadcaster, that will receive the lion's share of transfers, leaving less than 25% for newspapers. And as someone who has spent over 5 years listening, learning, and supporting digital news entrepreneurs, it is concerning that C-18 is seemingly even less helpful to them. We encourage the committee to find more opportunities to hear from the next generation of Canadian digital news innovators. Let me be clear, Canada is incredibly important to Meta. Canadians will always be able to use Facebook to connect with friends and family, to help build communities, and to grow their businesses. Les Canadiens pourront toujours.
Canadians will always be able to use Facebook to connect with friends and family, to build communities, and to grow their businesses.
But faced with adverse legislation based on false assumptions that defy the logic of how Facebook works, and which, if passed, will create globally unprecedented forms of financial liability for news links and content, we feel it is important to be transparent about the possibility that we may be forced to consider whether we continue to allow the sharing of news content
30
on
seconds.
Facebook. But faced with adverse legislation based on false assumptions that defy the logic of how Facebook works, and which, if passed, will create globally unprecedented forms of financial liability for news links and content, we feel it is important to be transparent about the possibility that we may be forced to consider whether we continue to allow the sharing of news content on Facebook in Canada. As always, we remain open to working with this committee and the government on solutions that are fact-based and reflects the interests of all Canadians.
Thank you very much.
Thank you.
Thank you. And I will now go to Mr. Hatfield. Mr. Hatfield, for 5 minutes, please.
Thank you. Good afternoon. I'm Matt Hatfield, and I'm the campaigns director of Open Media, a grassroots community of nearly 220,000 people in Canada that work together for an open, accessible, and surveillance-free internet. I'm speaking to you from the unceded territory of the Stolo, Tsleil-Waututh, Squamish, and Musqueam nations. My question today is this: who is in Bill C-18 and who's out? Who is producing high-quality journalism that deserves government-mandated subsidy and promotion? And who isn't? How much are they entitled to? And will the public ever have transparency to see these questions are being answered fairly? We believe the government is trying to dodge responsibility for answering these highly sensitive questions. Yet Bill C-18 still answers them. Burying these questions just means its answers are more obscure, secretive, unequal, and potentially damaging to trust in journalism. There's a real problem that C-18 is trying to solve. Canadians need high-quality, trusted, fact-checked journalism, and lots of it. Our democracy depends on it. And it's true that huge online platforms, Google and Meta chief amongst them, are collecting a lot of revenue in Canada. It's fair to ask them to contribute more of that revenue back to things that Canadians need. That's why we support the digital services tax, and that's why we wish that we were debating a much simpler version of this bill that directly taxed them. Linking news revenue primarily to the spread of news content on platforms is a toxic poison pill. News simply isn't a primary revenue driver on platforms. That's a fact. And a lot of the reporting of great importance to society is least likely to go socially viral. Linking news support to links and clicks gives both platforms and news publishers strong incentives to cheat the system in ways that discourage the spread of quality news. It fails to target the resulting funds where they're actually most needed, subsidizing today's biggest winners in news production while not bringing back lost outlets or supporting the emergence of new ones. It makes news outlets dependent on the continued success of online platforms to survive, which is a dangerous weakening of their credibility and independence. And because Bill C-18 uses links and clicks as a substitute for stronger evidence of public interest journalism, C-18 sets such a low bar for identifying a qualified news outlet, lower than the already flawed QCJO system, that low-quality outlets, click farms, and even malicious foreign actors could potentially qualify for mandatory promotion and subsidy. For these reasons, we believe without substantial amendment, Bill C-18 will be enormously destructive to the quality, distribution of, and public trust in Canadian journalism. The money's not going where it needs to. Minister Rodriguez has told us that small news publishers aren't really interested in Bill C-18's support. That's despite hundreds of publishers who've said otherwise. Yet Canada's news problem is largest in small communities that have lost their primary outlets and in hollowed out, downsized regional newsrooms. Will C-18 do anything to bring dead local outlets back? No. It does nothing today for communities with no existing news source. And if a small local outlet reopens, it locks them out from support until they hit a significant and possibly unattainable size. Will it induce major news chains to restaff downsized local divisions? How and why would it do that? What rational business will staff up the slow and expensive local accountability beat when your new primary revenue stream is the most viral and clickbaity of social media content? And that's before we consider that 75% of C-18's revenue is predicted to go to TV and radio broadcast, predominantly to giants like Bell, Rogers, and the CBC. This committee has criticized the secrecy of the deals Google and Meta make with publishers. Fair enough. So why doesn't Bill C-18 fix that? You can't rejuvenate public trust in journalism by making these problematic secret revenue deals larger, more secret, with more opportunity for the CRTC, government, and platforms themselves to quietly influence them. Under C-18, negotiated deals are still secret, as is the process for assessing eligibility for QCJO status and the reason for accepting or rejecting applicants. That's not a recipe for building trust in the news. But our biggest concern is what Bill C-18 will do to our online feeds. What kind of content do you think gets the most Facebook shares or the most retweets on Twitter? Do you think it is the in-depth, long-form...
Appel au règlement, Madame la Présidente.
Point of order, Madam Chair, please. This is Martin. Madam Chair.
Just stop my clock for a second so I don't eat into somebody's time. Just a minute. Sorry, I'm trying to move from A to B on my phone here, which is kind of not the easiest thing to do. Okay, I'm going to stop my clock. Right. Sorry.
Voilà.
Yes, Martin.
Madame,
Madam Chair, I'm sorry, and I apologize to Mr. Hatfield for my interruption. The interpreters are letting us know that Mr. Hatfield is speaking extremely fast and that it's difficult to follow him. So, Mr. Hatfield, if possible, I would like to ask you, through you, Madam Chair, to slow down your pace to allow the interpreters to do their work. Thank you. I'm sorry, Martin. I will speak more slowly.
Our biggest concern is what Bill C-18 will do to our online feeds. What kind of content do you think will get the most Facebook shares or the most retweets on Twitter? Do you think it is the in-depth, long-read investigative journalism that holds our leaders accountable? Or do you think it is puff pieces, fiery, unsourced op-eds, and outright misleading clickbait? Bill C-18 triples down on this kind of content. It nudges legitimate news outlets to make more of it, to see their shares grow and earn more compensation. It offers yellow journalists and content mill click farms a real possibility of qualifying for guaranteed mandatory platform subsidy and promotion. And it forbids platforms from taking any steps that would prioritize content from higher quality outlets, National Post, Globe and Mail, above that of any other qualifying publication. I don't always love my platform feed, but I don't want our government knowingly making it worse. And that's what C-18 currently does. Open media community members have sent nearly 8,000 emails to MPs asking for fixes to Bill C-18. Every one of us wants to see a flourishing Canadian news ecosystem. But without extensive amendment, there's considerable risk C-18 will make that news ecosystem worse, not better.
Thank you, Mr. Hatfield. Thank you very much. And now we go to Annick Charret, President of Fédération Nationale des Communications.
The Quebec Communications and Culture Federation.
Ms. Charret, for 5 minutes, please. And I give you a 31-second shout out. Thank you.
Bonjour.
Good day. I would like to let you know that the Federation represents 86 unions in Quebec, including news media unions. Our main concern is to maintain a strong, independent, diverse, and healthy press in Quebec. Healthy so that it is able to offer a diverse range of viewpoints, reflecting the Canadian image across the country. Too many media outlets have already had to close their doors because of the shift of ad revenue to digital platforms. To meet our objective, the market dysfunctions must be corrected. The digital platforms have cornered the ad revenue market, and this is why this legislation is extremely important in order to level the playing field between news media and digital platforms, which are all powerful and I would even say threatening. Our federation supports Bill C-18 on behalf of its members, but also on behalf of the members of the Canadian public, because news is essential to a democracy and to a well-informed population. This is what everyone wants. We would like to draw your attention to some possible areas for improvement. There are some exemptions that are too broad that could exempt foreign platforms from mandatory bargaining, and this would be to the detriment of a diversity of news viewpoints. we would like to note that news businesses are especially important in small communities. Small news players must be able to fairly bargain. Also, local media often only employ one journalist per outlet. We believe that the interpreter would like to note that Ms. Charette is speaking too fast for all of her.
Chair, it's Chris.
Pardon?
Yes, thank you. I'd like to let Ms. Charette know that the interpreters think you are speaking too quickly. So if you could slow down a little bit, please. Thank you.
Parfait. La loi ne devrait par contre s'appliquer.
However, the act should not only be applied to certain outlets that meet certain journalistic standards. The respect of journalistic standards of practice across all Western society is very important in determining the professional character of a news outlet. It is important to us our submission has certain suggestions for the independent auditor. The powers of the independent auditor are essential in order to guarantee that the benefits from C18 end up directly in newsrooms and benefit journalists. This reinvestment of new funding is key to ensure quality news journalism. The auditor's powers could be expanded. And the bill must also apply to all platforms. 30 seconds, Ms. Charette. To conclude, it is a moral obligation for news platforms to contribute part of their funds to news platforms. It is moral for this funding to be reinvested into our democracy. The market is severely imbalanced.
Ne devrait jamais primer sur les intérêts.
But the needs of the Canadian population are what is most important. Thank you.
Merci beaucoup, Madame Charette, and we're going to go now to the questions and answer section. I'd like to let witnesses know that the time allocated for questions and answers include questions and answers. So if everyone could be as crisp and to the point, it would really allow for more questions to be asked of the witnesses. So now we're going to begin with what is known as a 6-minute round. And I begin with Ms. Thomas, Rachel Thomas, for 6 minutes, please.
Thank you. I will direct my first question here to Mr. Chan at Meta. Mr. Chan, in your opening remarks, you talked about the open internet and how it allows for competition to thrive. However, you made reference to the fact that this legislation would actually harm that. In fact, the creator of the internet, Sir Tim Berners-Lee, has also said the same thing. When Australia came out with its legislation, he said that it threatened the intent of the internet to be an open and broad space where people could collaborate and share ideas freely. I'm hoping that perhaps you could expand on this. How does this legislation harm the internet or break it, as some have claimed?
Thank you very much, ma'am, for a very good question. I mean, I think this is really at the heart of what preoccupies a lot of people beyond, I think, just the platforms. I mean, simply put, links are really the lifeblood of the internet. Obviously, links connect people from one site to another. It facilitates effectively the free flow of information and therefore freedom of expression. And we have never seen in anywhere else in the world an attempt to regulate the free flow of information by putting into scope effectively a toll for links. That is wholly unprecedented globally. It runs counter to any notion of what a link is and how it operates. And I would just also say it runs counter to decision made by the Supreme Court of Canada back in 2011. And I'll just quote a segment of it here. I printed it out earlier, if I may, ma'am. It says, "The internet cannot, in short, provide access to information without hyperlinks. Limiting their usefulness would have the effect of seriously restricting the flow of information, and as a result, freedom of expression."
Ms. Thomas, I think your question has been answered. Do you have another question?
Yes, thank you. I apologize. My internet is unstable, and so I am cutting in and out a little bit. My apologies. My next question here will go to Matt at Open Media. Matt, you talked about the fact that Canadians do need high quality news sources, and you said that there's a great deal of variety that is required in order to maintain a democratic system that is healthy. But you also made a comment that Bill C-11 actually doesn't accomplish this stated intent. In fact, you seem to indicate that it would harm innovation and creativity and variety among news sources. Do you care to expand on why that's the case?
Yeah, that's right. And I'm going to springboard a bit off what Kevin was just saying here. So under this bill, we're attaching a cost to good information while leaving bad information free to spread without any cost. And the belief is that that will somehow lead to good information spreading more and faster. Does that seem right to you? I mean, we didn't need to be costing good journalism in this way. We could have found money for it without attaching this cost. And unfortunately, the decision of the drafters of C-18 has been to do this. In terms of concerns about the spread of bad information here, it's incentivizing existing outlets to produce more lower quality content. But because of how low the standards are in C-18 for recognizing quality information and quality information outlets, it's actually opening huge doors for a whole range of bad actors to enter Canada and to start spreading their misinformation. So we're talking about clickbait farms, the doctors can't believe this type people might take huge advantage of this legislation. And we're even talking about hostile foreign actors, groups like RT, but there's many more who might have a real interest in misleading Canadians and find a way of misusing this legislation to do so.
Thank you, Matt. I guess I'm just hoping that perhaps you can expand on this a little bit more. I understand with the cost of links that will perhaps change the variety that's available. But in addition to that, what about in terms of the qualification? Like, what about in terms of news sources actually being able to qualify? Will that enhance the amount of variety that is available online and ethnic media sources and smaller sources being able to, keep their share of the market, or will it in fact harm that?
Yeah, that's also a concern. So we're letting some bad actors in, and we're also freezing out newer, smaller businesses and more innovative businesses. Because funding's being allocated relative to the current distribution on platforms, it means that the platforms that are doing best today are the platforms that are getting most of this money. There's not sort of a way of getting these funds to spur new models that might actually succeed without this support for journalism.
Okay, thank you, Mr. Hatfield. Mr. Chan, I'm curious to know, it's been said that there's a disruption in the market in terms of advertising revenues. Certainly, it's shifting online versus, paper media. And so, I guess I'm just wondering then, like, this whole bill is based on this premise that we need to somehow, take lost ad revenue or make up for lost ad revenue in order to keep some news sources afloat, or at least enhance that. I'm curious as to what, Meta's take is on this.
You have 30 seconds, a little less than that, Ms. Chan, to answer. You're muted. Please unmute.
Oh, I'm so sorry. I guess I would simply say that as recent events have shown, nobody is immune from the market forces, the very significant competitive market forces in the advertising industry. We are no different. but it would be false to claim that this started because of digital platforms like Facebook. I think if you go back into the history of reporting on this, it goes back to the early 2000s, long before we existed and long before we monetized.
Thank you very much. I think the time is up. And I shall now go to the Liberals for Mr. Anthony Housefather for 6 minutes. Anthony, please.
Thank you, Madam Chair. And I want to start by saying I think it's pretty ironic that the last time that Meta was here, Mr. Chan was unable to tell me how much ad revenue Facebook derived in Canada, but somehow today was able to extrapolate how much value Facebook offered publishers for links that publishers, had Facebook send them to. So basically, I'm going to ask a number of questions. If I ask a yes or no question, I expect a yes or no answer, please. Last week, Facebook said they were disappointed that they weren't invited to come to committee. Mr. Dinsdale, did Facebook ever contact the chair of this committee or the clerk of this committee asking to appear?
I'm not aware of the intricacies of that. That would not be an answer.
Yesterday I checked with the clerk. The answer was no. The last time Facebook was here, Mr. Chan and Mr. Dinsdale, I asked a number of questions about the experience of Facebook in Australia when you threatened to take down pages because of the similar legislation to C18, and then Facebook did so, causing chaos for a week. You said at the time that you could not answer. You did not know what happened in Australia. As a result, this committee summoned Mark Zuckerberg, your CEO, who could have answered the questions, and he ignored the committee's summons. Given that last week Mr. Dinsdale made the same threat to Canada about shutting down pages, and Mr. Chan did the same in his testimony today, I certainly hope you're both able now to speak to the Australian experience. So various whistleblowers have stated that in order to plan for the Australian shutdown, they required multiple staff members to preemptively sign special NDAs. Mr. Dinsdale, do you normally require staff members at Facebook to plan to sign NDAs for major Facebook events?
Again, sir, that is not a part of the business that I am that familiar with. I would not be able to speak to that specific question.
Were you or Mr. Chan asked to sign an NDA to plan for an eventual takedown in Canada?
I would say, sir, that we are here to try to engage in the substance of the bill in the spirit of cooperation, and to express simply that if the legislation passes as it is proposed, we may be forced to consider whether or not we would take that action.
But I asked you a specific question.
Oh,
Mr.
Housefather.
Mr. Chan, the question is to Mr. Dinsdale. Mr. Dinsdale, the question was to Mr. Dinsdale. Mr. Dinsdale, did you or anyone that you know of, were you asked to sign a specific NDA to plan for a shutdown in Canada?
So again, we're here to engage on the substance of the bill in the spirit of cooperation. And what I can share is that if the bill passes as it is proposed, we may be forced to consider whether or not we would take any kind of action.
Okay, well, I guess I'm going to take that as you're refusing to answer whether you did or did not, and I would probably take that as an affirmative.
Mr. Housefather, would you like to ask me? I'd like to give you a yes
Mr. Chan,
no.
Please.
Whistleblower documents.
When a question is addressed to you, you can speak, and I'm afraid you cannot intervene right now.
Whistleblower documents from Australia said that although Facebook said implementing the ban was intended to affect only news outlets, executives knew its process for classifying news for the removal of pages was so broad, it would likely hit government pages and other health and social services. It did in fact hit over 170,000 pages, including the Department of Fire and Emergency Services, the Council on Homeless Persons, Suicide Prevention Australia, Domestic Violence Support pages, the Kids Cancer Project, the Royal Children's Hospital, the Jewish Holocaust Center, State Fire and Rescue during fire season, and municipal, state, territorial governmental pages. Facebook then said that this was a technical error that Facebook worked to correct, and that any suggestion that Facebook did this deliberately was categorically and obviously false. Mr. Dinsdale, do you agree that it was a technical error and that there was no attempt to shut down these pages?
My understanding of the situation is, as we've expressed it, that any of those takedowns would have been done in error and were rectified as quickly as possible.
Funny enough, they seem to have been rectified as soon as the Senate approved the revised bill with Facebook amendments. The Facebook response team was able to then do it within a matter of minutes when the Senate adopted the amendments, which was 8 days after the initial takedown. Can you explain, Mr. Dinsdale, why there was such a discrepancy, how these pages somehow couldn't get restored in a timely way, but then suddenly, when the Senate approved the new revised bill that Facebook had renegotiated, then the pages were magically restored?
I mean, that to me sounds somewhat, in all due respect, speculative. And so what I'm able to share is what we have shared, that any errors that were made were rectified as quickly as possible, sir.
Okay, that's fine. But what we've understood again from whistleblowers is that Facebook did not use a standard canary process to text this algorithm precision and identify, prevent overblocking before an action. And despite clear notice that the lockdown was affecting far more sites than publicly acknowledged, which would normally have triggered a pause or a rollback, senior executives ordered the full rollout to take effect within hours. So how then do we trust the fact that this was a technical error? And can I ask, did you do a postmortem in Australia? And can you assure us that the same situation won't reproduce itself in Canada?
30 seconds for an answer, Mr. Dinsdale.
Thank you, Dr. Fry. Sir, I think that what I can share is that, again, if the bill passes as it is proposed and we are forced to consider this option, that we would try to do it in as much consultation and transparency as is possible. What that means, I certainly am not in a position to elaborate, but I can certainly reiterate that any mistakes that were done in Australia were exactly that, mistakes.
Thank you very much, Mr. Housefather and Mr. Dinsdale. I'm going to move now to Martin Champeau from the Bloc Québécois for 6 minutes, Martin.
Merci, Madame la Présidente. Merci aux témoins.
Thank you, Madam Chair, and thank you to the witnesses for being at the committee with us today to speak to us about this important legislation. Like Mr. Housefather, I was also pleased to see that Mr. Chan had found his binder with Facebook's numbers, because last time we asked him questions about those figures on Facebook, it was quite difficult to have answers. But I see that that's not the case today. So, Mr. Chan, you might remember having a conversation last year with a professor who deals heavily with social media cases. In an interview at TVA with Mr. Roy, you were saying that Facebook and Google, but let's talk about Facebook today, has a lot of ad revenue that goes through news media. However, you were saying that the Australian news blocking, which you did as a protest, had no impact on news media. It said that the average ad revenue per user on Facebook is $82. So I'm talking in US dollars. In 2017 was equal to $451 million. And sir, I'm not the one who revised those figures. We can keep talking on the basis of a hypothesis, but no, I don't know about those numbers. So Mark Zuckerberg said that with the new Facebook algorithm, the ad revenue for Facebook, we can assume, was about $24 billion if we're talking about income related to Canadian news sources. Do you agree with this, Mr. Chan? No, and I believe that our problem with this is the lack of logic when it comes to the percentage at Facebook, which is not equal to the percentage of income. We have millions and billions of pieces of content people put on Facebook. Anyone, any person, a Canadian, a Quebecer, can see something like approximately 1,000 pieces of content per day. And the majority of that content is never seen by anyone because there's just too much content and not enough hours in the day.
And that's where I found that there's a lack of logic with this way of calculating. So in your opinion, the revenues that stem from sharing news content, you're saying that news organizations are wrong when they say what they say. Nevertheless, you've signed agreements with News Corp and others in Australia. So if news content is not bringing any revenue for Facebook, why did you then decide very magnanimously to sign these agreements? If it's not worth anything to you, if it's not bringing any revenue to Facebook, why are you signing agreements? Answer, let's be clear. We haven't signed commercial agreements in order to pay for free marketing. The marketing is already free. We've signed agreements, commercial agreements, in Australia, but also in Canada as well for the same reason, in order to develop new innovation models. We want to innovate on the platform, and we want to see internet tools innovate as well. So I think there's a lack of understanding from people who don't really understand the situation. We've signed agreements around the world. We're not paying for links. We've never paid for links. We're not paying right now for links, and we really don't want to pay for links because this would go against something that is very important, not only for our platform, Mr. Champoux, but for the internet in general. The internet is owned by everyone. Yes, of course, of course. I'm sure you're all. I'm sure Facebook could win the Nobel Generosity Prize. I have a question for Ms. Charette. I have very little time left, so I'd like to go to Ms. Charette. Talk about the importance of putting in place criteria of regarding journalism. I think it's an important topic. In 30 seconds, what do you mean by that? What criteria should we have within the law to make sure that news companies that are recognized and are eligible are good quality news companies? What is traditionally recognized as an ethics code in journalism, having a diversity of opinions, and those criteria are important to us because I think it was Google who said that anybody who publishes a newspaper, even if it's a newspaper that's basically not publishing any news, but basically being ads. I don't think we should be recognizing news companies because of the amount of employees, but rather if they respect journalism standards. There are criteria that they must respect if they want to be eligible from a fiscal standpoint. So I think it should be based on that. Thank you, Ms. Charette, says the chair.
Peter Julian for 6 minutes for the NDP. Peter, 6 minutes.
Madam Chair, I'm going to be subbing for Mr. Julian today. It's Mr. McGregor.
Oh, hi. Yes, Mr. McGregor.
Okay.
6 minutes, please.
Thank you very much. Thank you to all of our witnesses, and I'm going to try and do my best here on behalf of Mr. Julian with Bill C-18, but I do appreciate everyone's feedback on this bill. And Ms. Charette, I'd like to start with you. I was taking some notes as you made your opening statement, and I could very much relate to the concerns that you have and the willingness that you want to maintain a strong and diverse mediascape in Quebec, but I think that also applies to many regions in Canada as well. And I know we've been hearing from the FNCC and many stakeholders that Bill C-18 has set out 2 restrictive criteria for news media companies to be eligible for negotiations with the web giants. So I've got a couple of questions for you. The first one is, what would happen to thousands of small-sized news media companies, many of them which are non-profit organizations such as community radio, community TV, in Canada and Quebec, if Bill C-18's eligibility thresholds remain unchanged?
Je vais vous rapporter.
I'll bring you back, I think that these companies should have professional standards that uphold journalistic standards. If we're simply hosting a radio show, I don't think they should be eligible. But there are quite a bit of small media companies that have staff journalism. And of course, they should be eligible when their work is promoted through Facebook and when their work is shared through Facebook and Google. So it's important, if we want to hear more voices, if we want to multiply and amplify these voices, we need to take into account those small media organizations. If there are agreements signed with major media companies, it doesn't mean that it's going to cover everyone. We know that every media organization has suffered by the fact that now more ad revenue is received by the big companies. So the very few companies that still hold water should be maintained, of course. The Coopérative Nationale d'Information au Québec, which is regional newspapers, they had numbers regarding Facebook. They say that they saw a decrease in 22 to 23% of engagement through Facebook over the last year. So it seems that Facebook is not promoting contents that have links, but rather standalone content in order to not refer people outside of the Facebook environment. That is what stems from the analysis that was run. In case of the printed press, usually they get money when the link is there and when people click on the link and then they read on the newspaper's website, not through Facebook. So when that link has a market value and when that is not remunerated because it's in another Facebook publication and one which is less and less referenced by the Facebook platform, there's a lack of revenue. I'm not sure if I was clear on that in that answer, says Ms. Charette.
Appreciate that. And my second question related to the first. I want to get into a specific clause of the bill, specifically Clause 27. It deals with the eligibility. What would FNCC suggest to amend that clause that deals with eligibility so that we can lower the thresholds to include more small-sized news media companies, either business or nonprofit? I think that's just to help us for when we get to the clause-by-clause consideration of the bill.
If I may, I will look up Section 27 or Clause 27. I don't know it by heart. Clause 27. So we're talking about public broadcasters? Is that what you're referring to?
News businesses designation, Clause 27, under the title eligibility.
Yes, as I was saying, we believe that any professional media should have access regardless of size, but also specific information media, whether it's economic newspapers or arts and culture publications, because some major publications have an arts and culture section, an economy section, a sports section that's part of the general information. So the sports journalist or the economic journalist or the arts and culture journalist should also benefit from this agreement, even if they're not printing in a major paper. We also believe that the newsrooms of public broadcasters, there are not that many, of course, but they should have access to that because they also produce content. When talking about CBC and Radio-Canada, we all pay for that, for the production of that content. So that So the money, the contribution should be sent back to Radio-Canada and should be sent back to taxpayers, basically.
I'll end there. I'll end there, Madam Chair.
Thank you very much. And I'm afraid that I know that you were here to replace Mr. Julian, but those are big shoes to fill, Mr. McGregor, and you did it very well. Thank you. So now I would like to go to the next round, and the next round is a 5-minute round. And so I will begin for the Conservatives, Marilyn Gladu. 5 minutes, please, Ms. Gladu.
Thank you, Chair, and thank you to the witnesses for appearing today. I'm happy to see my Liberal colleagues beginning to realize that without significant amendments to this bill, we may see some unintended negative consequences, like 22 million Canadians having their content blocked by Meta. And so my question for Mr. Chan is, in Australia, when the content was blocked there after similar legislation was brought, there were amendments that were requested and put in place. What were those amendments? What should we be doing to this bill, C-18, in order to prevent that same adverse outcome?
Well, ma'am, if I may, I just wanted to just correct the record on a previous round where I was not allowed to answer, but I had very clear answers. I think for the record, it's important for the committee to hear the truth. So I never signed an NDA, just to be clear. So I wouldn't want someone making the opposite claim, because that would obviously inappropriate. I believe it's fair to say, and the team just wanted me to correct the record, we did seek an opportunity to appear with committee members, and I believe we were told that we should fully expect to be invited. But as everybody will appreciate, and perhaps it's important for me to outline how these things work, because not everybody gets the opportunity and the fortune to appear. You obviously can't force your way into a committee. You need to be invited. They're called invitations. And so I just want to correct the record on those two things.
Yes, and I was very clear to make sure that the committee needed to invite and hear from what Meta would say. So what changes do we need to do to C-18 to make sure we don't have the same consequences as Australia?
Well, ma'am, I think there are a number of amendments which we are going to share with the committee in due course. I think.
Will you submit them in writing?
Yes, we will, ma'am.
Excellent. That's all I need then. Thank you. A question for Mr. Hatfield. I only have 5 minutes.
I understand.
I'm very concerned as well that although the intention of the legislation is to try to protect these smaller news organizations that have missed revenue, the criteria that has been set doesn't allow anybody with just one journalist or a couple of part-time journalists to participate, has criteria that doesn't even require the basic standards of journalism that we say in Canada. They can self-define and are focused on general news. So I'm worried that we're going to be excluding, for example, ethnic media. Many times these are mom and pop shops or smaller organizations, and they may not be considered general news. Do you share that concern?
Yes, absolutely. I think the challenge we're seeing in the criteria that are set out is they focus on sort of organizational features. So having 2 journalists, having a certain focus to your news, and they don't seem to have any examination of the quality of what's being produced. Are you making great journalism? Are you contributing to the discourse in Canada? And we think both of those things need to be amended, a little bit of tightening in one area and a little bit of loosening in the other, in order to get people a result that they'll actually like.
And I'm also concerned that the government here is now determining who's included and who's excluded. And it's rewarding the larger media conglomerates and not the smaller ones that was intended. And it doesn't certainly seem to be freedom of expression and freedom of the media. Would you agree, Mr. Hatfield?
I definitely think there's a concern here. I mean, no one wants the government deciding, who does good news. That's a scary prospect for anyone who thinks seriously about it. At the same time, the way they've set this up, they've actually forbidden private entities from making those judgments either. So they're kind of creating a news system where no one is taking a hard look at whether this is quality content that's being distributed. And it's actually undue interference in the rights of a platform like Meta or Google or others to make those decisions. And I think people want to see the most trusted outlets appear fairly high up in their feeds. The National Posts, the Wall Street Journals, the Globes, and so on.
Excellent, thank you. And Mr. Chan, do you also agree
30
that
seconds?
this bill is an erosion of freedom of expression in Canada?
Yes, ma'am. As I've noted earlier, it is challenging when you include within scope effectively a toll on links. You are going to end up seeing severe friction on that, and that is an erosion of freedom of expression. And I would note, if I may, Madame, Ms. Gladue, that
actually, through the chair, please, Mr. Chan.
Madam Chair, I would also note that it is, of course, doubly challenging because 2022 is the year that Canada chairs the Freedom Online Coalition, which is very much for and supportive of a free and open internet.
Thank you very much, Mr. Chan. Ms. Gladue, your time is up. I'm sorry. And now we are going to go to Mr. Biddle, Chris Biddle, for the Liberals for 5 minutes, please. Chris.
So much, Madam Chair. And it's kind of shocking that Facebook throws a public temper tantrum to appear before this committee and then refuses to answer questions unless they're friendly softballs from the Conservatives. I don't know why you just didn't go ahead and have a press conference standing shoulder to shoulder with the Conservatives while you threaten Canadians. Mr. Disdale, you stand here and threaten Canadians to do what you did in Australia, which is to take away supports, take away information about vaccines, take away information about suicide, crisis centres, take away information from their fire services. You put Australians' lives at risk and you come here and threaten the same thing to Canadians? It's absolutely shocking. This is modern-day robber baron tactics that Meta is demonstrating. And you say, don't regulate us. We're good corporate actors. It truly is amazing to look back at what happened in Australia.
Chair, point of order.
Yes, Ms. Thomas.
Thank you, Madam Chair. There have been times in this committee where assumptions like the one that Mr. Biddle is making or accusations towards a witness have been made. And as chair, you've ruled them out of order. And so I'm wondering if you would consider to do the same in this case.
Yes, that's a judgment call on my part, Ms. Thomas, and I don't think that Mr. Grettel is being very aggressive in his questioning, but I don't think he is being very disrespectful to the witness. Thank you.
Madam Chair, I trust my time was paused. I haven't even asked a question. Thank you. I haven't even asked a question yet. And we heard about the generosity of Facebook providing $230 million worth of links, but on the other side, we're going to take away all of your ad revenue from news agencies as well, which is an interesting generosity. There's a suggestion that from Facebook that this will break the internet, but we've heard from Microsoft, which may know a thing or two more about the internet than I do, that such legislation won't. It didn't in Australia. It won't happen again. The fear-mongering just continues. So let's go to Australia if we can. In February 16, 2001, the House of Representatives passes the initial bill. The day after that, there is a overreach takedown, including all of the sites that Mr. Housefather mentioned. And Facebook's official response that day, on day 2, February 18, was the takedown is going according to plan. Mr. Disdale, was that a mistake, as you claimed earlier?
Sir, I'm obviously not able to speak to the communications that are happening at that time.
See, and again, why didn't you? And if you're,
excuse me, there was a bit of difficulty in hearing Mr. Disdale answer, so I will stop the clock and let him re-answer, please, because I couldn't hear it. There was echoing.
Sir, thank you, Dr. Fry. I think I would express as well that our intent with last week's communication was to signal the degree to how unworkable it is for our business, and that we may not have the opportunity to share these concerns, and that we're grateful to have the opportunity to share these concerns with the committee. And we hope that we can create a more evidence-based piece of legislation that takes into consideration how platforms and the internet work.
Thank you. Go ahead, Chris.
Another question, another non-answer by Facebook from a company that demanded to be here. Should I just ask softballs, Mr. Disdale? Is that what you're looking for? Like the contempt, and I've dealt with Facebook before, committees before, with Mr. Chan, and the contempt that Meta has for the parliamentary process. Mr. Housefather went through it earlier. I noticed today that a judge in the United States fined Meta $25 million for repeatedly and intentionally violating U.S. campaign finance laws. So I guess we know what Facebook and Meta think about the democratic process. At the end of the day, we see Mr. Zuckerberg in whistleblower communications celebrating the outcome, that outcome putting the lives of Australians in jeopardy. Was that a mistake on Mr. Zuckerberg's part?
So again, I believe that we've expressed the point that there were mistakes that were made that we have been public about. And again, that our engagement here today is to really talk about our concerns with the legislation in front of us, which is concerns about
it's based on the
representation of the
excuse me, Mr. Disdale, this is my time. This is based on the Australian model, this legislation. I think most people know, and you've threatened the same thing to put the lives of Canadians at risk. I guess the question is, you put thousands, perhaps millions of Australians' lives at risk. Are you willing to do the same thing to Canadians?
I think this legislation is...
The question wasn't to you, Mr. Chan.
Mr. Chan.
Oh, I didn't realize. I thought it was open to Meta.
No, it was to Mr. Dinsdale. I was aware of that. Thank you.
Oh, I'm
should probably listen, Mr. Chan.
Oh, I'm listening very carefully.
I think, again, sir, as Mr. Chan has expressed, the outcome of the legislation in Australia was that we do not, in fact, pay for links. So a model that is based off of the Australian model is in some ways inapplicable because we are not designated in Australia.
30 seconds.
The deals that we have done in Australia.
I appreciate that, Mr. Disdale.
The sharing of links, et cetera.
I appreciate that, Mr. Disdale, and it's disappointing again to see these robber baron tactics to come in and threaten parliamentarians, threaten Canadians. I know I'll be reaching out to Whistleblower Aid and Libby Liu, their CEO, and request that they submit a briefing to this committee because the tactics that Facebook employed and Meta employed in Australia to endanger the lives of citizens without a care. And even if you're saying it was a mistake, that doesn't play out in emails and correspondence between your CEO and yourselves, and you come here unwilling or unable to talk about it. And it's truly shameful what you're doing, sir.
Thank
you, Mr. Biddle. I would say that
Thank
those are
you, Mr. Biddle. I'm afraid that time is up. I'm now going to move to Mr. Shampoo from the Bloc Québécois for 2.5 minutes. Please, Martin.
Merci.
Thank you, Madam Chair. I'd like to go back to Madame Charette, please, and talk about what we talked about on the quality of journalism and how we can ensure that these eligible companies are serious. In the propositions, the amendments that were suggested to us, Google would like us to do away with Article 50, that article that talks about that undue preference. And what Google says is that this would stop their platform to have that vetting process with some information. So I think, if I understand correctly, we would just rely on Google to see which content is reliable and which isn't. So what do you think, as an organization that represents a large number of journalists and media outlets? Well, that bill in Australia actually wanted to regulate economic relations and the imbalance that existed between companies and economic activities. So now, when it comes to journalists or professionals, there are a number of regulations in Canada. And so these organizations look at all of this and can receive information to say, for instance, that one media outlet isn't reporting correctly on certain things. So the quality is being assessed, and these organizations exist in Europe, in Canada as well. So a professional journalist, a qualified journalist, will answer to those regulations. Yeah, but you talked about these eligibility criteria for VCQs, but 30 seconds, says the chair. Look, what I'd like to see would be more criteria that ensure more quality. We talked about ethical criteria earlier, but do you think we should really include that in the bill? And should it be law? Yes, that would be a great thing, says the chair, the witness. Thank you, Madame Charette.
All right, and I'm going to go now to the NDP, Mr. McGregor, for 2.5 minutes, please.
Thank you, Madam Chair. Mr. Chan, I'd like to turn my questions to you. I'll level with you. I have had some concerns about your company and its influence on our democratic institutions and on our civil society. My main role in the House of Commons is as our public safety critic. I sit on the Standing Committee of Public Safety and National Security. Earlier this year, we did a report into ideologically motivated violent extremism, and we heard some pretty damning testimony about the role that social media companies have played, especially with misinformation, disinformation, and plain fake news. In the article that you wrote on October the 21st, you have made that threat that you may be forced to consider whether Facebook continues to allow the sharing of news content in Canada. I mean, is that what's really going on here? You've had all of this damning evidence against your company about its role in sharing misinformation, disinformation. Are you seriously now considering making the situation worse by getting rid of credible journalism that is one of the bulwarks we have in a democratic society? Is that what's going on here, Mr. Chan?
Well, if I may, I mean, I would say, oh, I'm sorry, Madam Fry, it appears that there's echo, or there was.
Yes, maybe try again, and if there is continuing echo, I will stop the clock.
I think it's important to indicate that on Facebook, what you actually see are the conversations and exchanges of 21 million Canadians, and they are their opinions, and they are their communications to one another and to friends and family, and I think that's what you see on Facebook. Having said that, I think perhaps my colleague Mark has some thoughts on sort of just fact-checking and the general idea of misinformation and how it pertains to C18 that might be helpful for legislators. And so if I may, I turn it to Mark to try to answer that one.
Thank you. It is an important point of reference to consider that we do have the world's largest fact-checking network program of any platform that includes 90 fact-checkers accredited by the International Fact-Checking Network, which is a subsidiary of the Poynter Institute. Our primary pillars in that are that we identify, we review, and we act on content. And identify is the fact checkers themselves are able to look for content they want to fact check. They then review. We also actually use artificial intelligence to do that work as well, to suggest things. They then review it, and they're able to apply labels like false, altered, partly false, etc. And then the important part is act.
Got 5 seconds, Mr. Tinsdale.
Okay, the important part is act, which is, I think, what has been pointed out by both Mr. von Finkelstein and Mr. Hatfield around our concerns that if there are the undue preferences clauses in the bill, do not allow us to reduce the spread of misinformation in that sense, then that should be concerning to everybody.
Thank you very much, Mr. Dinsdale. Now we are going to go to for the Conservatives for 5 minutes. Mr. Waugh, Kevin, 5 minutes, please.
Yes, thank you, Madam Chair. It was interesting the other day hearing from the Minister of Heritage quoting 468 news outlets have closed in this country since 2008. I will also say many of those news outlets that closed were Bell Media, were Rogers, were National Post, were Torstar, the same organizations that want to be at the trough of C18. It's really interesting. What the minister didn't say in his testimony, that we've had over 200 news operations open in this country, independent organizations that have opened in this country. So I just wanted to make that statement, because with this bill is not going to save the media in this country. We have seen Bell Rogers, National Post star, tear down in small communities like Swift Current, like Lloydminster, like Prince Albert, like Yorkton, like Red Deer, like Kelowna, like Kamloops. I can go on and on and on. So if the panel thinks that this bill is going to save rural media, think again. People are getting their information a little differently. I'm going to go to Mr. Von Finkenstein. You were the former chair of the CRTC. So, as you know, you don't have any experience in regulating news or even the competition matters. I just told you about how many news outlets have closed in this country. But suddenly now the CRTC is going to have the power to determine what news publishers benefit, the definition of a journalist, and will oversee arbitration, including the picking of an arbitrator. Do you think, Mr. Von Finkenstein, the CRTC should be given a prominent role as this on this bill C-18?
Thank you for that question. My purpose appearing here today was to try to say the existing legislation as it is doesn't work. It needs to be amended. And I've focused my point. If it's assuming that we use the concept that the government has adopted of mandatory bargaining between platforms and news publishers, then to make it work, these changes that I suggested, and I gave you some draft amendments, it's a minimum. Is it a good way to do this? Is this really a function that the CRTC can do and should do? I personally have never done it. Can they go into it? It depends on who the leadership is and what resources are being given. But, I mean, the whole concept, to my mind, is not the right way to go about doing this. I mean, we have, if you want to subsidize news publishers, you can do it in a myriad of other ways. This strikes to me as being unnecessarily complicated. But as I say, if you do it, and that's my assumption that as this bill will pass, then at least it should be amended as I suggested.
Define DNI. Define that.
What was my first point? That DNI definition, as in the Act, is totally unworkable. It's based on all sorts of concepts that are not objective. They depend on the context. They all come from competition. And I know that because I was Commissioner of Competition for 7 years. So if you want to apply this is very difficult. And you have to do it. So therefore, I suggest forget about this. People self-identifying or the CRTC identifying them, give the minister the power to identify them by regulation, but he should consult with the Commissioner of Competition, so he does it in an informed, systematic way based on jurisdiction in competition.
Define what a journalist is.
That's a very, there are lots of issues about that. What is a journalist or not? If we have various definitions that you can use. I presume if this bill comes into effect, the CRTC will issue guidelines what they consider a journalist, and will base themselves on existing precedents.
I would say, because I was one, the journalist has certainly changed over the years. And I think the public has actually wanted change in journalism. We've seen the public broadcaster being very heavily involved in how they actually direct their journalists in their reporting. We've seen that not only with the Emergencies Act, but other things here in Parliament. Is the CRTC capable of handling something they've never had to do before because they're radio and television? Now we're being asked them to deal with essentially the newspaper industry. Are they capable of this?
Thank you, Kevin. You're over time, and I'm going to have to not allow the answer right now. So hopefully somebody can pick that up. I'm going to now go to the Liberals for 5 minutes. Lisa Hepner. Lisa, 5 minutes.
Thank you, Chair. We have been speaking about good journalism today, so I'd like to draw the committee's attention to a Wall Street Journal article from last May. Facebook deliberately caused havoc in Australia to influence new law, whistleblowers say. Last year, when Facebook blocked news in Australia in response to potential legislation making platforms pay publishers for content, it also took down the pages of Australian hospitals, emergency services, and charities. It publicly called the resulting chaos inadvertent. Internally, the preemptive strike was hailed as a strategic masterstroke. Facebook documents and testimony filed to US and Australian authorities by whistleblowers allege that the social media giant deliberately created an overly broad and sloppy process to take down pages, allowing swaths of the Australian government and health services to be caught in its web just as the country was launching COVID vaccinations. The goal, according to whistleblowers and documents, was to exert maximum negotiating leverage over the Australian Parliament, which was voting on the first law in the world that would require platforms such as Google and Facebook to pay news outlets for content. Despite saying it was targeting only news outlets, the company deployed an algorithm for deciding what pages to take down that it knew was certain to affect more than publishers, according to documents and people familiar with the matter. Mr. Dinsdale, is this true? Was the Australian havoc deliberate?
Thank you for the question. Again, I'm not sure how many other ways I can answer this question other than that I wasn't involved in Australia. I understand that some mistakes were made.
Okay,
We've talked about those mistakes.
Thank you.
And
So
we want
I'll
to
go
avoid that
on
outcome
and,
again, which is why we want to be transparent in the committee.
Thank you. The documents also show multiple Facebook employees tried to raise alarms about the impact and offer possible solutions, only to receive a minimal or delayed response from the leaders of the teams in charge. After 5 days that caused disorder throughout the country, Australia's parliament amended the proposed law to the degree that a year after its passage, its most onerous provisions haven't been applied to Facebook or its parent company Meta Platforms. We landed exactly where we wanted to, wrote Campbell Brown, Facebook's head of partnerships, who pressed for the company's aggressive stance in a congratulatory email to her team minutes after the Australian Senate voted to approve the watered-down bill at the end of February 2021. Facebook chief executive Mark Zuckerberg and chief operating officer Sheryl Sandberg chimed in with congratulations as well, with Ms. Sandberg praising the thoughtfulness of the strategy and the precision of the execution. Is that what happened, Mr. Dinsdale?
Again, madam, I was not involved in Australia.
Kevin, sorry, then I'll ask Mr. Chan, is that what happened?
I am not aware as well. I think what's important, though, ma'am,
Thank
is
you.
I want to talk
you
to you
answered
about
my
the
question.
substance
Let me go on,
bill.
Mr. Chan. I heard you in
Yes.
your opening statement say that Meta does not unfairly benefit from news, that in fact the reverse is true. But we all know that Facebook's main source of success is on the data it collects from its users. I think 22 million, according to Ms. Gladue earlier. So are you telling us that the data that you collect on people sharing and reading news has no value whatsoever to Facebook?
Well, ma'am, I would just put it this way, I guess. In 2017, there was 5% of content was potentially sort of in the news domain. It is now moved
How much
to
time do
3%.
people spend on news on your platform? Can you give us any numbers?
I don't have that. What I can tell you, because we don't keep track of that, but what I can tell
Your
you.
most important metric is time spent on this platform. We know that you track how many people spend time on specific content, but you say that you don't track how much time people spend on news on your platform?
Ma'am, I guess I can answer it, if you allow me, in a different way, which is to say that Canadians tell us they want less news on Facebook, not more, and we are moving to meet.
Do you have any statistics to back this up that you can share with our committee?
I think we have, well, we've been clear about this since February of 2021. We can look to see if there's anything. But it is not only the stated preference of Canadians on Facebook, but maybe if you'll permit me to share.
So we already know that you've
30 seconds
heard already in this committee that you've entered in negotiation or commercial deals, or you've entered into deals with publishers in Canada. Why would you do that if there was no value to you?
We did it in order to incentivize a more robust digital transition so that we would not be in a situation where legacy media sort of continue the same approach.
Okay, thank you. I think my time's up.
Yes, thanks, Issa. Your time is up. Now, I'd like the committee to know that we have time, if everyone is very concise, to go one full round. So, I will now go to Mr. Shields for the third round. Mr. Shields for the Conservatives. 5 minutes, please.
Thank you, Madam Chair. I find it interesting, some of the witnesses and their comments, but to Mr. Chan, are you a private company that people purchase advertising with your business?
Sorry, Mr. Shields, do you mean, so people buy advertising to place it on Facebook?
Right.
Yes.
Thank you. So one of the things I've heard from newspaper publications, in particular weeklies, that the federal government used to purchase hundreds of millions of dollars in newspaper advertising in newspapers. They have moved that to your type of business. So has the federal government, in a sense, like Australia, they moved their advertising to your platform?
Well, Mr. Shields, if that's, I don't know the precise number. But if that is, obviously I've seen advertising from the government of Canada on our site. So I presume that there's some amount of that, yes.
So one of the things that newspaper people, particularly in weekly industry, said, if the federal government wanted to support the weekly newspaper, they would return their advertising to that platform. So the government is making money when it sends it to you. And now the weekly newspapers are saying, please return it to us as a sense of advertising. So thank you. Mr. Finkelstein, when you talked about the CRTC not being in a position to take on because they haven't been doing this, are we looking at an arrive cam situation where there is a company that then subcontracts all over the place to try to do this? How do you think the CRTC is going to take on this challenge?
Well, I'm not running the CRTC right now, but so all I can surmise, I would imagine that mostly they will try to create in-house expertise to do with this, and as a temporary measure may hire from the outside, get some consultants, get a subcontract or something like that. But clearly, this is going to be now part of their main function, and they will strive to develop the necessary expertise to do it in-house, as they've done with anything else that has been assigned to them.
And that's a good point, in the sense that they're probably looking at transition in the sense of doing this. So you would suggest that they will be looking for consultants. You've been in that position when things have come to the CRTC. They're going to be looking at a lengthy process then, even in transition, to try to deal with this legislation.
Understand how the CRTC functions. The CRTC is a court of records. They don't just make decisions. They have an issue, they publicize it, they ask for submissions, they get the submissions, they have a hearing, and the hearing can be in person or can be on paper, and then after the hearing, the commissioners, with the help of staff, make certain decisions, and which then can be public. And so it is a long process. You don't make it out of thin air, you do it on the basis of what's you mandated in the legislation and the input you get from people who come before you, who are affected by the legislation and who suggest you should do A or B or C.
And what you would suggest by that, in the sense that you're setting up a very, very quasi-judicial process that, in legal terms, in quasi-judicial, that takes a lot of work to set up all of the infrastructure, human infrastructure to go with it.
If this act is implemented, is enacted and proclaimed in force, the CRTC will clearly do the very first thing is have hearings, maybe one mega hearing on it or separate ones on specific issues. So in order to get the necessary input from the people affected, so and then put it together and make it into a workable scheme. Like, for instance, the question that has been discussed here today, what's the DNI? They will seek definite input from everybody, assuming the legislation is not changed, in order to somehow give this very loose mandate that they have in the section some form, some structure, and come out with some policy, some directive, so that people can understand what it is. After all, the whole issue of all of these things is to make things predictable, to establish rules so people know what they are and can comply with it.
And that would be the same situation with defining what journalism is.
That would be one of the issues. And I mean, journalism to define is very difficult. I remember when we did the free trade agreement, I was a chief lawyer on that, and the question came up, what's a journalist and so he gets contemporary entry to Canada or not? And it was a huge debate between us and the Americans, and then it was a huge debate in Parliament as to whether we had done it right or wrong. And because journalism is a nice, broad concept, but specifically it defies precise definition, or it's very difficult.
Thank you. Mr. Hatfield, the question you had in the sense of limiting people who might be in it, I had the experience in the 60s of being involved with some of the first Indigenous newspapers as they attempted to do it. Is this the
That's
kind
on mute,
of...
Madam Frey.
Mr. Cheed, your time has been well over. Thank you very much. You've gone, you've gone well over your time. Thank you. I'm sorry I was muted and you couldn't hear me saying that. It's not your fault, it's mine. Okay, now I would like to go to Mr. Housefather, Anthony, for 5 minutes. Thank you.
Thank you, Madam Chair. And I just want to start by saying that, of course, the committee can invite whoever it wants as witnesses, but normally we start from a list of people who approach our clerk saying they wish to appear. And according to our clerk, yesterday, nobody had ever approached from Meta asking to appear. I'd like to ask Mr. Dinsdale. Mr. Dinsdale, you were the first person, it was, I think, on the 21st of October, that made, and I'll call it a threat, you may not call it a threat, that Facebook would withdraw news content in Canada. Mr. Dinsdale, did you make that decision on your own, or did you consult with other people at Facebook in order to determine that you would make such a statement?
I think, sir, you can appreciate that anything that we would discuss is not made in isolation, that we're trying to express is the concerns that we have with the legislation, and that we are very happy and thankful for the opportunity to discuss them today. The fact that the legislation does not describe the relationship between publishers and platforms in the way that we agree with.
I was just asking if you spoke with anybody else at Facebook. I'm assuming from your answer is yes. Before you made that statement, did you receive instructions from Mark Zuckerberg to make that statement? Did you have an approval from central head office in California to make that statement?
A direct conversation with Mr. Zuckerberg would be somewhat above my officer, so I'm not able to.
Were you advised that he authorized you to make that statement? Were you advised that it was approved by him?
I don't think there's ever any discussion of it in that sense. We work as a group that examines these things from a global perspective and from a local perspective, and anything that was done was part of the conversations about the impact of the bills and what they could be in Canada, and also. But I mean, essentially, there was no directive in that sense.
So I'm gonna. This will be the last question on this, I promise. But the Canadian team would not have the authority to make such a decision, to make such a comment on its own. You certainly had and you felt the support of your board and your executive team in California to make that statement, did you not?
Again, sir, when I look at the context of how we discuss these things, I'm privy to the people within the group that I work with, and some of the communications that happen there. But I think it's safe to presume that we are not kind of out on a limb here, and sharing anything that's the company at its in its foundation doesn't believe in.
So no, of course. So I mean, clearly this is a systematic procedure at Facebook to threaten national governments when they don't like their legislation with certain actions, like you did in Australia and like you did in Canada, which again, according to whistleblowers, was celebrated by both Ms. Sandberg and Mr. Zuckerberg.
Again, sir, this is an expression of our concerns with the bill and the concerns with the
But you didn't just
express
didn't just express your concerns with the bill. That would be one thing. You threatened to take an action that would affect 21.5 million users in Canada.
I believe, sir, we expressed our concerns with the bill and wanted to be transparent about the unintended consequences that it might lead to.
Well, they would be very intended consequences. The intended consequences would be Meta would make a decision that it intended to make to strip Canadian users the ability to see news. So let me ask you, Mr. Dinsdale, as you may recall, Facebook confirmed through news reports that it had manually adjusted its algorithms during the 2020 US election, during the week of the election, to favor authoritative news brands in order to increase the integrity of information. Why would you have done this if news has no value?
I think that and I believe that Mr. Chan was about to answer some of this question as well, that the movement of our users and the preference of our users, as he indicated, are moving away from news. And we see that in independent reporting as well. We see that in the Reuters Digital News Report, where people answered a survey in that sense, and 21% of people said on Facebook they feel like they see too much news and would like to see less, and only 3% said they'd like to see more. So when you look at the movements that are happening within our platform, then it's towards that user preference that we're moving.
Of course, but what you're threatening to do is
30
take down
seconds, Anthony.
What you're threatening to do is take down authoritative news and leave disinformation on your platform.
Sir, as I mentioned before,
I didn't ask you a question. Mr. Chen, you had talked about the agreements you currently have with Canadian publishers. You said they're not commercial licensing agreements. Will you provide this committee with details of those agreements? And I would remind you, we can summon them.
Well, I am so glad that we live in a liberal democracy and operate in a market economy. And as you can appreciate, any kind of commercial arrangements that we have struck with partners are subject to the law and the rule of law. I cannot do that as much as I believe you may have asked somebody from a publication to do the same. I don't think that they can.
Thank you very much, Mr.
I don't
Chan.
have them on me either, by the way.
Thank you, Mr. Chan. Your time is up. I'm sorry. I'm going to go to Mr. Champoux for the block. Martin, 2.5, please.
Merci, Madame la Présidente.
Thank you, Madam Chair. It's not a secret for Madam Chair?
Ça va?
Is it okay?
C'est Martin, Madame la Présidente.
It's Martin, Madam Chair. It's me.
You didn't sound like Martin at all. All right, Martin, can you begin? 2.5 minutes, please.
Avec plaisir.
All right, please do. Thank you, Madam Chair. It's not a secret for anyone that technology has evolved immensely. Before there were newspapers, and of course we would have written news the morning after. Then there was the radio in the 30s or 40s, then radio newsrooms, then TV. And these are all media that produce their own journalistic content. And news has developed over time. But things changed enormously with the internet. In fact, the world changed. Our usual habits changed wholesale. But the issue is that social media who share news content does not produce the content. So it's an unusual competition for that industry who had to adapt. So if we don't adequately protect our newsrooms, our information media, it's simple, they will simply disappear. And then who will produce quality journalistic content? I think the answer, actually the question begs the answer. So you're against the way this bill is written, but as a former chair, Mr. Finkelstein of the CRTC, I'm sure you're aware that the news industry must be protected in a certain way. So if it's not through C18 that compels companies that share news that are produced by our newsrooms, if they are not protected through the negotiation process, what would be options? I'm asking your opinion as a former chair. What would be a solution to ensure that news companies get their fair share that was taken suddenly by those online platforms? Answer. It's very hard to answer your question if we're talking about subsidizing. If we want to subsidize the news, we must do it through a more simple system. For example, there's the CMF system, under which there's a cost for each company that distribute film, and that goes into a fund, and then the envelope is shared with film producers and filmmakers.
I think we have run out of time, Martin.
Merci, Monsieur Finkelstein.
Thank you, sir.
Mr. McGregor for the NDP, 2 minutes and a half. Thank you.
Madam Chair, Mr. Chan, I'd like to direct my question to you. So On Meta's website, you do have a section on combating misinformation. You claim to stop false news from spreading, removing content that violates your policies, and giving people information to make sound decisions. I'm just trying to see how that statement on your site, that commitment, jives with the threat that you are considering whether you're going to allow the sharing of actual news content. Like if you're threatening to pull links, how are you going to ensure that you are actually combating misinformation if that journalism is not allowed to be on your site? Do you not understand that many Facebook users do rely on your platform for accurate information, especially from local community news outlets? I mean, I think eliminating those news links will further diminish our democracy. Do you think it's moral for Facebook to be doing that, to making that kind of threat?
Well, what we understand is that Canadians want less news on Facebook, not more. I think you're right that users may want to see good information, and that's why we partner, for example, with the Public Health Agency of Canada. That's why we partner with Elections Canada to get good information to Canadians. I think what you raise, though, is a central concern of us for C18. We've heard other independent experts say that if there is a requirement not to preference certain publications, and I think Mr. von Finkelstein may be alluding to this, then the approach that we have taken to reduce, to downrank bad information will be taken away from us. At least that's what other experts have said. And if that's the case, then I worry that C18 exacerbates the issue, doesn't solve it, with all due respect. But thank you for the substantive question. I'm trying to give you a substantive answer. I hope that's helpful.
Madam Chair, I'll leave it at that. I only have 30 seconds. Thank you.
All right. Well, thank you. Thank you very much, Mr. McGregor. And I'm now going to move to Mrs. Gladue for 5 minutes, please.
Thank you, Chair. I'm going to start off talking about some of the things that the Minister of Heritage said when he testified and comments that he has made. One of them is that he said this legislation is not intended to mandate payment for links. Mr. Hatfield, is that an accurate characterization in your view?
I don't think anyone really knows how the determinations are going to be made around what the payments are based on. But spread of links and content and clicks appear to be the only criteria that are at all quantifiable in this bill. It's either that or vibes from the CRTC, just a sense that there must be an intangible amount of extra value being delivered in the text of the bill.
Thank you. And Mr. Chan, do you think this legislation is intended to mandate payment for links?
I do, ma'am, because if you look at the way it's constructed, the bill is globally unprecedented in its scope. It ingests any possible definition of any news content down to the unprecedented definition of a hyperlink. And I'll just give you one very simple example. If you go to your favorite publication in Canada on Facebook, on the Facebook page, just scroll through it and see how many links you count versus, I don't know, some other content, and you will know just by your own verification what we're trying to put our arms around through this bill or what we're trying to count. It is the vast majority, the predominance is links.
Yeah, it's clear to me that this is a mandate of payment for links, and that is not what the Minister of Heritage said. He also testified that he had a list of DNIs, but he would not share them with the group. Now, these digital news intermediaries, Mr. von Finkenstein, I think you talked about how a better mechanism would be for the minister to be able to designate who was the DNI, because the definition is so unclear and in some cases maybe unconstitutional, because they say that it's all the digital news intermediaries that are under the control of the federal government, and so far that would mean none. So my question to you is, if the minister does have the list, like he said he did, do you think it should be shared with this group before we approve C18?
But it would certainly be helpful if he did that as an example of what he has in mind and how he interprets the legislation. That being said, if the legislation stays as it is, it will be the decision of the CRTC, or actually it will be the decision of the DNIs who have to come forward and voluntarily identify themselves and be accepted by the CRTC. And as well, the CRTC can ask those who have not come forward to furnish us with information so that the CRTC can make the decision whether they DNI or not, based on the very loose criteria that's set out in the bill.
And does the CRTC have extensive experience in determining who is a digital news intermediary?
None. And certainly, as I mentioned before, the criteria are all based on competition concepts, something that the CRTC does not have a competence in. It can, of course, ask for assistance from the Bureau of Competition, but it would be better if this, as I say, this is really a decision by the government saying these are the major DNIs and they should contribute, and they should explain how they came to that decision based on the criteria set out in the Act.
Thank you. One other concern I have is that sometimes when costs are leveled in a certain direction, so for example, if Google and Meta are going to be paying for links, sometimes these things trickle down to the consumer eventually because somebody has to pay in order to keep profit margins for private companies that can take independent commercial business decisions. So, Mr. Chan, do you think there is any possibility that this might ultimately result in Canadians having to pay to have news links shared?
Oh my goodness, this is a finance question. I honestly don't know, but I think you're right, ma'am, in stating, as any good finance official will tell you, taxes can be notoriously leaky, and I think that's something that everybody should think about generally. But obviously, we haven't ever had any conversation about that. I would say, though, ma'am, perhaps you asked me about amendments. One big amendment that would get us away
I
from
only
this.
have a half an hour, Mr. Chan, so please
sorry.
send your amendments to the committee. Mr. Hatfield, in the interest of an open internet, an open and free internet, do you think there is a possibility that charging people for a link would sort of destroy the whole openness of the internet as we see it?
30 seconds left, so a quick answer.
It makes it worse. We're making it more difficult to share good information, which means more bad information will spread. The bill shouldn't be set up that way.
Thank you for your testimony.
Thank you, Mr. Ledoux. And I will now turn to the final question. We'll go to the Liberal, Mr. Biddle. Chris, 5 minutes, please.
Madam Chair. To Mr. Hartfield, I was looking on your website. It said 50% of your revenue comes from grassroots donations. Are there tech giants that contribute to your organization as well, such as Google?
Yeah, so that's a minimum of 50% comes from small grassroots donations. Google was a donor in our last financial year. They aren't in this one, but they haven't been before. But we don't take more than 15% from anyone.
Thank you so much. Mr. Chen, I'd like to dig in a little bit. You said earlier in your testimony that the deals that you have made aren't commercial agreements, but are deals to develop new innovative models with publishers. Is that correct?
What I said was that the commercial arrangements that we have established with various publishers was to incentivize new behavior that would spur digital innovation.
It just was interesting. When it was put to you as a commercial agreement earlier, you denied that they were commercial agreements, but when Mr. Housefather asked for deals, they became commercial agreements so that you wouldn't have to. Again, Mr. Chan, don't talk over me. It's not good for the translators. Please wait till I finish. Again, I know you have contempt for what we're doing here, and we've been through this. You and I have been through this before on different legislation, and history is repeating itself. And so, if it is, well, whatever it is in terms of a deal to.
Point of order.
Sorry,
yes, Ms. Thomas, your point of order.
Thank you, Chair. Chair, Mr. Biddle is choosing to speak directly to the witness and again is badgering him and assuming intent. That's super inappropriate. Inappropriate to speak directly to him rather than to you, Chair. And secondly, inappropriate to assume intent. That's badgering the witness.
Thank you very much for that point, Ms. Thomas. I also note that there have been a couple of witnesses who do not speak to me. They speak directly to the questioner, and I made it clear that one should speak through the chair. So I think we've had a bunch of people going against the rules a little bit, and I've allowed it to happen in the interest of getting the questions and answers through. Mr. Biddle, please continue.
May I, Madam Chair, point of
Yes,
order?
Ms. Thomas.
I'm not talking with regards to the conduct of the witness. We understand that they're here for a short duration of time, and so they may not understand the full rules. Mr. Biddle has been here for quite some time, and as a former lawyer, he understands the importance of following rules. So, Madam Chair, perhaps you could offer some direction there.
Thank you very much, Ms. Thomas. If I think that Mr. Biddle is in any way, shape, or form disrespectful, I will tell him so. Thank you very much. Mr. Biddle, continue.
I think Mrs. Thomas watches too much Law and Order. I don't know where badgering the witness is in the standing orders. Though it is good of the Conservatives to stand up to defend Facebook whenever possible during this, we're not getting a lot of answers if it's not a softball question from the Conservative Party. So back to my original point in terms of, and sometimes during your testimony, it's a deal to innovate. Sometimes it's
Madam
commercial.
Chair, point of order.
Ms. Thomas, we have very little time, and I would really like this questioner to be able to ask questions of the witnesses and have the witnesses answer. So, is it a totally new point of order? Because we are, in fact, carrying out the orders of the day. So, if it's not a point of order, what is it? Is it a point of information? Is it a point of privilege? What is it, Ms. Thomas?
Point of order, Madam Chair.
Yes.
Thank you. Madam Chair, you are operating in a rather discriminatory manner. There are times where you have gone after me for the exact same behavior that Biddle is engaging in right now. In fact, I actually am not nearly as vile as he is. And so I would ask you to be fair in your ruling, Madam Chair. Thank you.
Thank you, Ms. Thomas, and I will be fair in my ruling. Mr. Biddle, please continue your question.
No, you're not.
Thank you very much, Madam Chair. And I'd just like to point out that in a point of order that I show more respect, I was called vile. But anyways, I guess that's the way the Conservatives are going to operate. So I guess back to my original point, Mr. Chan. Sometimes it's a deal to innovate in your testimony. Sometimes it's a commercial agreement. And if the government's doing it, it's a tax. How can you explain the difference between those two things, or three things, I guess, that your testimony changes from point to point, depending who's asking you a question?
Well, I'd like to see the transcript. I don't think I've ever used the word tax. So first of all, that has to be clear. Second of all, there's, in fact, the best, I'm sorry I have to point this out, but this is just, the logic escapes me, so I have to say this. The best commercial deals, I hope, are always going to lead to innovative outcomes.
Thank you very much. I believe you said taxes are leaky, was I believe your exact statement, but interesting enough. I think you just said that a couple of seconds ago. There's
As a general
certain
point,
again,
Mr.
Mr. Chan,
Point,
you've been before committees enough that you know not to speak over members of Parliament. I know you claim to have respect for this process, but again, like this happened in Proc when you appeared before us and trying to speak over me and trying to shout me down. Your company's Robin Baron tactics are on display. At least we can show a little bit of respect to each other in this process, and you can go out and have your joint press conference with the Conservatives afterwards. Mr. Dinsdale, do you know if the company is planning to threaten the government of the United States of America? Because I know there's similar legislation before the United States Congress.
Sir, again, I think we're here today to try to responsibly share the committee our concerns about the bill. We're focused on
threaten the people of Canada, and I'm just asking if you're planning to do the same thing to the people of the United States, or is it just that it's an American company, so the American government's not going to get threatened, just the Canadian and Australian governments?
Again, sir, I think we're here to try to share a point of view on Canadian legislation and the misrepresentation that it has of the value exchange between publishers and platforms, the challenge that we have with paying to then have the right to provide free marketing to publishers, and our concerns that are expressed by independent publishers about how this legislation could potentially stifle innovation.
You've got 10 seconds left, Chris. I think we... would you like to do anything in that 10 seconds?
No, thank you, Madam Chair.
It's now 5. It's now 5. Thank you very much. Now, We have a hard stop at today at 3 p.m. I wanted to say, as a chair, on observing and listening to what was going on, that I have heard repeatedly people asking about journalism. I think when we did a study back in 2017 of the very issue, I chaired the Heritage Committee then. What was very clear was that so-called news companies in Canada have very different rules that they must follow. Their news must be verifiable. It must be careful not to call names or issue threats. And so it has got certain things it must do under the criminal code. I think that there is a great concern here. Does this apply to companies like Google, Facebook, Meta, in terms of their own ability? We live in an age of disinformation. Do they have the same international constraints on being verifiable and accountable to the people in printing news? That's a question I just wanted to ask.
Ma'am, did you want me to answer?
Yes, please, very quickly.
Oh, sure. I mean, I think the challenge, and perhaps that gets to the heart of C18, is that what we're talking about when we talk about what's on these platforms and on the internet is people's speech. And people's speech is subject to different considerations than, I would dare say, what an editor decides should be in a newspaper.
Okay, thank you very much. Now I think we have now three more minutes to go, and I will entertain a motion for adjourning this meeting. And I want to thank the witnesses for coming. I know it's been heated and hot in some instances, but thank you for coming, and we appreciate your sharing. Thank you, Ms. Gladue. The meeting is now adjourned.